All right. So now beginning, this is Chelsea Burch versus MARTA and Ms. Hill Carter, and this is 2021cv347281. Today is April 18th, 2022, and I'm going to state it one more time. I am in chambers, and our proceedings are now being broadcast on the court's YouTube live stream channel to satisfy the obligation that we take very seriously, that the public's business should remain open and accessible to it. We are here this morning so we are appearing entirely via Zoom. Does anyone think that anyone has shown up personally or been instructed to appear for this hearing?
Not for the plaintiff, Your Honor.
Counsel?
Not for the defense either.
Okay, because I'll happily go sound for anyone, but again, that case is ongoing this morning. So we are appearing entirely via Zoom, and Mr. McIntosh, I believe this is your motion. Would you like to go forward?
Yes, Your Honor. Thank you very much. I apologize for my voice.
What's wrong with you?
I'm dealing with an illness. I don't know. It's been going on for a week. I think I got it from my daughter. I'm not sure. So I'll try to speak clearly and speak up.
Well, I hope you're not feeling bad, but we're looking forward to hearing from you. Go ahead.
I'm here, Your Honor. I'm making it. May it please the court. Brent McIntosh for the plaintiff, Chelsea Burch. I filed this motion to set aside Your Honor's order, and all I'm asking for is that the order granting summary judgment that was dated March 2nd of this year be set aside to allow for me to file a response. I believe there is some evidence, and the ultimate outcome may not change upon Your Honor's viewing of such evidence, but I believe there is some evidence in support of my client's claim, and I'd like the opportunity to present it. This motion is being brought pursuant to OCGA 91160D1 due to for relief from a judgment or order, and it's based on a lack of not receiving a notice that this motion was filed. So I'm just going to briefly state some of the facts, and I think some of these, now that counsel filed her response, I became aware of some additional facts, and I don't think some of these at least are in dispute. Counsel filed her motion on Odyssey e-file on November 24th. Based on evidence she produced, indicated that she did the e-file and serve through that service. I've provided affidavits from numerous people, including myself, Mr. Smith, the law partner here, and the office manager whose email was linked to the Odyssey service, showing that we never received notice of that filing and never received the motion. The defendant's certificate of service on the motion indicates it was served via e-file, addressed to myself and Mr. Smith at our office address with our emails on it. I submitted an affidavit from myself and Mr. Smith stating that we never received it. It appears, again, based on what MARTA attorney has provided, that she did the e-file and serve, which it would have been sent, and the notice would have been sent to the office manager, Ophelia Benitez. And I have two affidavits from her kind of stating two different issues. She never received a copy of the notice from Odyssey. And the reason is because she was on maternity leave, and that's the subject of her second affidavit. She was on maternity leave from November 1st, 2021 through February 14th, 2022. And she had an away message on her email that says that she's away, and provided another individual in the office with an email to reach her if it was needed. So that explains, counsel provided evidence showing that the notice from Odyssey was sent, and it was never opened because she wasn't monitoring the email because she was on maternity leave. So being this is an e-service issue, electronic service issue, there's a statute on this, which I've never had much of a reason to look at, but I've had a lot more reason to look at it in recent weeks. OCGA 911.5. Pursuant to that statute, plaintiff counsel consented to e-service in two ways. First, by putting my email, Brent B. McIntosh at calvinsmithlaw.com, was on the complaint that we filed. That's one way you can consent to electronic service by putting your name on the signature block of a complaint. The second was getting an email account, as Your Honor requested be done in the case management order, and as we do in any other case, having an email account affiliated with either Odyssey or Peach Court or whatever the services are. That's what the statute requires. That's what Your Honor required in the case management order. We assert respectfully, Your Honor, that we did that. We made an account with Odyssey. That's how we got a copy of Your Honor's order from March 2nd. And we complied with the statute and the case management order in doing that. So based on those facts that we've presented through the affidavits, we've provided evidence. Again, Your Honor, this isn't an issue of throwing blame on anybody. I'm not casting blame on certainly not on the defense counsel. She did the e-file and serve through Odyssey, as I'm sure does with other things. It's just, this is an issue of first instance issue in my practice where, something was sent to an away message. Odyssey, the automated service, isn't going to resend it to the second email. I've never known them to do that, and they didn't do that in this case. So I believe it's an issue of miscommunication in the age of electronic filing. But in the bottom line of the matter is, we never got a copy of it. We never had a copy that it was filed. We were never given a chance to respond. You can't get you can't get summary judgment by default. Counsel presented evidence in her motion that could certainly support summary judgment being granted, but I believe we have evidence to, countervailing evidence against that, and we just were never given a chance to present it. So I think, in the interests of justice and equity, I'm respectfully requesting, Your Honor, just to set that aside and allow us time to respond to the merits of the motion. I believe this is a little bit analogous, and I mentioned this in my brief. It's analogous to circumstances where cases are put on trial calendars or notices from clerks go out and the parties don't get it. There are cases, and I cited two of them, where the courts stated, that the parties did what they were supposed to do to put the courts on notice of the right address and that sort of thing, and the notices just never got to them. And that was getting that order set aside to allow for the issue to be addressed was something that the Court of Appeals has done in other cases. And I think I respectfully request that would be warranted here. I'll be glad to take Your Honor's questions, but I don't have anything further other than what's stated in my motions and what I've stated here.
Mr. McIntosh, and I apologize for not knowing this, were you on, you personally, the B. McIntosh at calvinsmithlaw.com, were you a service contact in the on the Odyssey account?
I was not, Your Honor.
Why not?
Well,
is that just not the way your office does things?
Yeah, well, and it's not going forward. It's going to be different, Your Honor. But yes, partly, Your Honor, I think, and I'm sure any attorney could say this, but the way it's done, the reason it's done the way it's done is because of and we've experienced it a lot, Your Honor, the constant turnover in the office. So we have a general email that gets, that the office manager that's put on it so that, anything that comes can, in case an attorney leaves, and they're the only contact, then it wouldn't get received either. So that's why the office does it the way they do it. Admittedly, Your Honor, I guess if blame needs to be put on anybody, it's me for not putting my specific email on the Odyssey as an email contact. I'm going to do that now going forward in all of my cases so this doesn't happen again. I don't imagine the office manager is going to go on maternity leave anytime soon, but I don't want any other issue, whether it be maternity leave or something else, for this to happen again. Because it needless to say, Your Honor, I was surprised to see how this has gone. And had I put my email contact on it, I would have filed a response.
Okay. So, and do I further, is kind of a second question, then I'll hear from Ms. Patel. Are you suggesting that?
I didn't file a response within 30 days because I'm not on it, Your Honor. Yes, I would have proceeded and I would have made it.
No, but is your argument today in part, and we had a good response had we made it? Mr. McIntosh, come back. Oh dear. Ms. Cummings, is it I? Ms.
No, he's
Kelly?
frozen on mine.
Okay, we lost Ms. This is off the record, Ms. Johnson. We lost a lawyer in our last hearing, and I rarely have two freezings in one day, but so I just want to make sure it's not me. The last thing we want is from there. Oh, he's going to come back. Is for Mr. McIntosh to have been dropped by the ether. Okay. Let's hear it. Ms. Johnson, while I got you, what's your telephone number?
Certainly, Your Honor. My direct line is area code 714
Okay.
348
Okay.
6800.
Who you with?
I'm with Elizabeth Gallo.
You want to come down here and work for the court?
I don't know. What can you offer me?
Well, I tell you what, it's a good time to be a court reporter. I'll tell you that much. Ms. Patel, you should love on her because you're there he is.
Sorry, Your Honor. I'm going to have to do it on my phone now. We had Wi-Fi, having internet issues here. I apologize again.
Well, I guarantee you, Mr. McIntosh, the last thing we were going to do today is proceed without you because of technological difficulties. So,
Well, I appreciate that, Your Honor. I'm very, very sorry. I don't know if Your Honor asked me another question. I didn't hear it.
I did. I'm going to go back to that. Ms. Johnson, if we can go back on the record. The question that I think I asked you that I don't think you heard was, is your argument today that had I known and had I responded, we would have had a good response? Is that essentially what I'm hearing?
Yes, Your Honor. And it was no, I apologize, Your Honor.
No, I got two Mr. McIntoshes.
Okay, I left that one, Your Honor. Okay. Yes, Your Honor. My position is that there, and it was kind of a difficult decision that I made about, how to proceed with this, because I do think there is evidence that we have video evidence, and if I'm allowed to submit a response, Your Honor, I'll have to ask Your Honor or your clerk how to submit that to Your Honor. But I believe there is evidence, MARTA surveillance evidence of the driving of the subject bus, in addition to deposition testimony, which some of it was presented by counsel for MARTA. But I believe that, yes, Your Honor, there is sufficient evidence that we would have been able to defeat summary judgment.
Okay. And is it too late now to start or does res judicata prevent you from starting another suit?
I believe it prevents me, Your Honor. I had pondered that as well. I had thought about dismissing it and refiling it, but I don't believe I'm able to, or I would have probably done that.
Okay. Okay, Ms. Patel.
Good morning, Your Honor. Janki Patel here on behalf of the defendants. And you have my response, which I will touch upon that a little bit. But basically, we're here today to decide a question of, was there service in this case? And the question has to be decided by you under OCGA 911-5F. And plaintiff is saying they never received it. Defendant is saying that, yes, they did. And we have shown evidence of that. So first, they argue that they never consented to electronic service. Have shown you how they did when they filed this case using Ms. Benitez's email address under OCGA 911-5F4. And as you have questioned, counsel, he could have added himself as a service contact at that point, or he could have had multiple service contacts as we did on my end. I had 3 people from my firm just to ensure that deadlines aren't missed and things of that nature. They used that email address as the primary email address, not just for Ms. Benitez, but they actually said it was Calvin Smith's email address. That was on them. They purposefully did that. We didn't do that. And then, they try to say that I'm trying to mean that 911-5F1 does not just mean an unrepresented person. I am reading that as just the plain language of that statute in comparison to subsection then 4. Or section 5, as when it talks about an attorney versus a person. I don't believe that that's very, is going to matter as much in your decision today, because as I've stated, They have been represented since the beginning of this case. They initiated this case via electronic service using that email address. And they did submit 2 affidavits from Ms. Benitez saying that she cannot locate any record that she received that electronic service of defendant's motion for summary judgment, which she stated on March 4th. But then she comes back a month and 3 days later and kind of sort of changes the story that I was on maternity leave, which in essence is saying, yes, I probably did receive that email, but I was on maternity leave. Again, this isn't defendant's fault. Although I do sympathize with them, it's not the attorney that was on maternity leave, Your Honor, in which case defendant would have had notice of that via leave of court. It was the office manager. And it truly comes down to a mismanagement on their part, because they could have easily swapped out that email address for another office manager, or they could have added Mr. McIntosh's email. They could have added Mr. Smith's email, who is actually the attorney of record on this case as listed. And then they also submit to you another affidavit from Mr. Emmanuel Lopez with their reply saying that he was never served and he was designated as a person to receive service when she was out on maternity leave. But again, counsel's already admitted e-file sends automatically generated emails. They're not going to look at that. I would like to point out that, you are here to decide, Your Honor, the credibility of these affidavits. Mr. Lopez cannot even get his name correct in the affidavit. He says his name is Calvin Smith. So it just goes to the credibility of what they are saying. In contrast, defendant has shown with their response in opposition that their motion was properly served utilizing e-file and serve. They're claiming it was through no fault of plaintiff or plaintiff's counsel that they didn't receive notice, but at the end of the day, it really comes down to them and their mismanagement, because they were responsible to ensure that they monitored that email account, even if she was out on maternity leave. As I've already mentioned, they could have swapped it. They could have added additional service contacts, but they did not do that. And it comes down to the plaintiff missed a deadline because of this. And he is essentially claiming that you granted summary judgment by default, which is not what your court did. They essentially missed the 30 days to respond, to present evidence in opposition to the motion. You granted summary judgment based on the evidence in the record. And I did submit the full affidavits, which I'm sure your court did consider when considering this issue and granting summary judgment. So
is that, can I hear that, counsel, as an affirmation on MARTA's part that you're entitled to this summary judgment, no matter who showed up?
yes.
Okay. Okay. Anything else?
All I will say, that's all, Your Honor.
Okay. All right, Mr. McIntosh, I'll let you have the last word.
And I just wanted to clarify something, Your Honor. Two things. I didn't argue, and I might have worded it poorly in my original motion. I wasn't arguing that we never consented. I just said there was multiple ways you can consent. We never filed a specific document stating we consent. But as I said when I first opened, we did consent to the 2 methods, my email as in the complaint, and then obviously filing on Odyssey, you consent. And I do want to address, we're not changing a story here, Your Honor. This is not when I filed my original motion and did the affidavits, I didn't have any evidence that they had served. I thought, admittedly, Your Honor, it was a mistake. It was just an honest mistake on their part. They filed it. It was never even served. When counsel provided the evidence showing that it was done e-file and serve and the envelope was sent by Odyssey, then my issue was, okay, well, then why wasn't it? And it says it was never opened. Well, why was that? Why did that happen? Because Ms. Benitez looked back in her email and didn't get any receipt of it. So what happened here? So that's where the maternity leave came in. I'm not trying to change the story or manufacture something. It was simply trying to provide an explanation for since defense counsel provided that evidence that it was done with e-file and serve. Why wasn't the service envelope opened? Because it bounced back due to the maternity leave message. So I just wanted to address that, Your Honor. I'm not trying to change the story or, do stuff because we missed the deadline. We were trying to provide an explanation for why we didn't file a response.
Okay. All right. I'll get something out as soon as possible. Yes.
Can I just add something?
No. We've got a schedule there. But let me ask this. This is a final judgment, which means where we are now, were it not for the motion to set aside, we have a final judgment in the case, meaning we could have a direct appeal, correct?
Correct, Your Honor, although that there was, and that's one, there was an issue with timing on that under the stat, you know, as Your Honor's word, 30, the actual order granting summary judgment, that time to appeal has passed without Your Honor extending that time under OCGA 5639.
But I mean, if I deny the motion to set aside, you can appeal.
Oh, yes, Your
Correct.
Honor, yes,
Okay.
yes.
Okay. Okay. Do we need to hear anything else on the motion for you to have in the record? You got your affidavits, you got your response, you have your argument.
I'm not aware of anything, Your Honor, sorry.
Okay. Okay. Well, I will, Ms. Patel, I'm sorry to cut you off, but I feel strongly about argument, response, argument. And so we'll get something out as soon as we can.
Thank you, Judge.
Okay. All right. Thank you, Ms. Johnson. Did y'all want to share in the takedown? I guess I should clarify that.
Yes, Your Honor, that'll be fine.
Okay. All right. Well, thank y'all very much. I hope everybody has a good day. Stay safe.
Thank you, Your
you.
Honor. Sorry for the technological issue there. I apologize.